If you don't have a will and you have a child, run, don't walk, to get your will done. Hey guys, Koukun here. Today I'm going to talk about getting a will set up for yourself. This is one of those topics that most people try to avoid just because it's a very difficult topic to have a conversation about. You're talking about your own death, the death of your family members, and you're discussing what to do if someone were to die. So definitely not the most fun topic out there. But if you're an adult, this is one of those things you just have to get done and have to put in place. If you own a property, you really should have a will so that your beneficiaries, your estate, the people who are in your life know what your wishes are for those properties. And especially if you have a child, definitely get it done. You want to make sure that the person of your choosing gets to take care of your child if something were to happen to you. The downsides to not having a will are if you were to pass away unexpectedly, it takes a much longer process for your estate, which is all of your assets and liabilities kind of put together, right? Your estate is what then pays out anything to your beneficiaries, be it your spouse, your children, and it takes a much longer time for that to happen. So if you don't have a will in place, it goes through a court process, which can be much longer. So you definitely want to have a will to make it as easy as possible for your family. And it's really one of those things that can put a lot of stress on your family, especially if you have parents, siblings, children, and a larger extended family. There's many cases for conflict where people are unsure what your wishes were and think that, you would have wanted this or that, and it just makes it a much more difficult time than it needs to be, especially when they're already facing the difficulty of you having passed away. So I personally just got my will done using a website called Willful. So it costs $99 to make a will, $125 if you get sort of the combination of a will and a power of attorney. I thought it was a great deal, and to me, the benefit was it was just quick and as simple as possible. They ask you a couple of questions. You just fill it in, your name, your spouse's name, who you want your assets to go to. If you and your spouse are not alive at the time of your death, then who does it then pass on to? And it kind of prompts you to fill in the information of the people in your life that you want to include on this will. And the nice part about Willful is that you can update it as many times as you want in the future without paying anything extra. So you paid the one time, and then in the future, if things change, you have another child, someone in your family passes away who was on the will, you can make changes to your will without paying anything extra. And the only sort of downside to Willful, and it's not really Willful, but rather the process of making a will in Ontario, you have to print it out every time, you have to sign it, and you have to have two witnesses sign it who are not on the will. So it has to be sort of a third party that's not a beneficiary on that will, and all three of you have to sign it at the same time. So some of the biggest drawbacks, other than those that I've mentioned, if you don't have a will, are especially when it comes to common law spouses. In Ontario right now, common law spouses do not automatically benefit from your estate. So you could be in a relationship where you've lived together with someone for many, many years, and you just choose not to get married, but you are living as if you're married. You don't automatically get the assets of your common law spouse, and you don't automatically become the executor of the estate. There are some cases where if someone passes away, even though they've been living with a common law spouse, if they have children from prior relationships, the assets of that person may pass on to those children or to other people within their direct family connected through blood versus through that common law relationship. So especially if you're in that situation, definitely put a will together ASAP. The other scenario that is not included is if you have grandchildren, or if you are a grandchild, then definitely think about your grandparents. But if you have grandchildren and you want to, for example, pay for their education, if you want to pass on something for them to get started in their life, grandchildren don't automatically get a stake in a grandparent's estate. So if you don't have a will, it goes through the automatic court process, and then the first person to get any benefit is your spouse. So your spouse would get $200,000, and then anything after the $200,000 will be split between your spouse and your children. So if you have grandchildren, it kind of will skip your grandchildren and just go to your spouse and your children, and that'll be the end of it. Also, if you have an elderly parent who you want to support, they again are not automatically included in the will. So if you want them to get a benefit of your estate, you need to have a will and put them in there. Otherwise, like I mentioned, it'll go to your spouse, it'll go to your children. Hopefully, if you and your spouse are on the same page about supporting your parents, then they'll do that. But again, it does create an odd situation though if you are a retired couple where, say, you have a nest egg that both of you are planning on using for your retirement. If one of you were to pass away, the spouse gets the first 200,000, but what if it was a larger nest egg that you were planning on using throughout retirement? Then before you get the entire amount, part of it gets passed on to your children who may not need it. So a bit of an odd situation, definitely. Again, this is why it really just makes sense to get a will done so that, you're clearly outlining who gets what. Another part is if you actually have some charities you want to support, if you don't have a will, there's no clear intention of where you wanted your funds to go. So if there's a charity you support, a cause you support, you want a part of your assets to go there. There's no way for whoever's taking care of your estate to be able to do that. And the worst situation is if you don't have any blood relatives, if you don't have any family, you have some assets and you don't create a will, then all of your funds just go to the government. So you want to have a will if you're even in that situation so that at least your assets can go towards a cause that you feel good about. And like I mentioned, if you have a child, it's very important you have a will so that you can list who you want the guardian to be. And you know what? This is also a good time to have a conversation with that person so that you let them know that, I'm putting you in my will as the guardian of my children. Do you accept that as a responsibility? Because it's not an easy responsibility to give to someone. And if they do, then it's good to have that conversation first, and then they're aware if something were to happen to you, they are in that position. So finally, here's some curious facts. So other than what I mentioned about the first 200,000 going to the spouse, the rest being split between your spouse and your children, if you have no spouse or children, then it goes to your grandchildren. If you don't have grandchildren, then it goes to your parents. If you don't have parents, it goes to your brothers and sisters. If you have no surviving brothers and sisters, you have nieces and nephews. However, if one of those nieces and nephews had died, it doesn't automatically go to their children. If only distant relatives survive, then it becomes more complex and you should probably speak to a lawyer. The very interesting thing is if you list someone as an heir to your estate, but after you pass away, they then pass away before the estate is wrapped up, their beneficiaries then become the beneficiary of your estate. So the portion you would have given to them then goes to the estate. If you have a beneficiary on your will, you pass away and then all of a sudden they pass away for some reason, the portion that you had willed to them then gets passed on to their beneficiaries of their estate. So they also needed to have a will in order. Anyways, just some curious facts. I know this is a topic that most people don't want to think about, don't want to talk about, but we put so much effort in our lives when it comes to our finances, when it comes to investing. We think so much about it. We discuss the best investments. We discuss, where do we want to put our money? What do we want to do? Get financial freedom. There's all these ideas that are way more sexy, way more interesting to discuss and learn about. I still feel like this is one of those few things that it just needs to be done to really encompass a proper plan for your financial life. So for that $99 or $125, definitely get it done. I'll have a link in the description if you want to get $20 off. But whether it's Willful, whether it's some other company, whether you just talk to your lawyer and get it done, definitely you want to have something in place so that your family's protected and your intentions are clear if something were to happen to you. And you know what? You may never need it, but it's better to have it in place than for something to happen to you. And then now your family's dealt with the passing of you and sort of the mess that they need to figure out without you being there. So hope you found that helpful. Until next time, all the best. Take care.